Friends, a very good evening. Today I have to discuss some specific provision of Arbitration and Conciliation Act like place of arbitration, arbitrability and fast track arbitration. Place of arbitration is mentioned under section 20 of the Arbitration and Conciliation Act. The party are free to agree on the place of arbitration. Section 21 says. Section 22 says, failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. Section 23 says, notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the party, meet at any place it considered appropriate for consultation among its members, for hearing witness, expert or the party, or for inspection of document, good or other property. Arbitrability is also an important question in the Arbitration and Conciliation Act, and if some cases are not arbitrable, then there is no purpose of arbitration. Section 2 definition is given, and in this definition part, under section 3, there is mention that this part shall not affect any other law for the time being in force, by virtue of which certain dispute may not be submitted to arbitration. It is written in section 3 of the Arbitration and Conciliation Act. The question of seat is also discussed in Balco judgment, and there are some ground to contest on arbitral award. Party are under any legal disability, award does not comply with the law, proper notice was not received, beyond the scope of arbitration, arbitral proceeding does not comply with the agreement, composite of the arbitral body does not comply with the law, arbitral proceeding does not comply with the law, award was not made binding on the party, award was set aside or revoked by the competent authority of the state. So we can challenge a arbitral award under section 34. The arbitral award is the final and conclusive decision granted by the arbitrator, whether in domestic or international arbitration. In the matter of enforcement of a domestic arbitral award, the award holder has to wait 90 days after receiving the award to apply to the appropriate forum for its execution. The award can be questioned during the transition period in compliance with section 34 of the Act. After the expiration of the time period, if a court considers the award enforceable at the execution point, the authority of the arbitral award can't be questioned any further. As we know that section 34 speaks about application for setting aside arbitral award. Section 35, finality of arbitral award. Section 36 discuss about enforcement of award. Section 37, appealable order. In the case of Booz Allen and Bimal Kishore Shah and others versus Jayesh Dinesh Shah and others, dispute beyond the jurisdiction of arbitration tribunal. Some dispute which are not and covered under arbitration tribunal. These disputes are criminal offense, matrimonial dispute, guardianship matter, insolvency petitions, testamentary suits, trust dispute, labor and industrial dispute, tenancy and eviction matters. There is separate law of tenancy and rents, and this is also not covered under arbitration. In this case, court also observed a right in rem is right exercisable against the word at large. In contrast, a right in personam is one exercisable against a specific individual. In personam proceeding thus decide the personal right and interest of the party named in the action, whereas action in rem are directed against a property itself and determine the right of the party exercisable against the public at large. The latter has an ergonomous effect. The Supreme Court concluded that traditionally all disputes related to right in personam are considered amenable to arbitration, and all disputes relating to right in rem are required to be adjudicated by court and public tribunal. All the matter which is related to larger public has to deal by court, public court, and the private matters will be dealt by the tribunal. Tribunal can also deal private matters. Fast track arbitration, there is provision of fast track arbitration. A strict time limit policy conducting in 6 months, only written submission, oral hearing conducted only on request, sole arbitrator, fee are decided by party and not court, prevent interviewing witness, reduction of 5% of arbitrator fee every month of delay in award. Fast track procedure is mentioned under section 29B of the Arbitration and Conciliation Act. Notwithstanding anything contained in this act, the party to an arbitration agreement may at any stage, either before or at the time of appointment of arbiter tribunal, agree in writing to have their dispute resolved by fast track procedure as specified